Anyway, my name is Lauren Lambert. I am an attorney here in Salt Lake. I'm also a board member of Offer. I graduated from the University of Utah, then Brigham Young to law school in '87, and I've been an attorney since then. I started my career clerking for a judge, Judge Harding, Harding Sr., who's now retired down in the 4th District Court in Provo. And then I was in the military for 3 years and 3 months, extended a little bit during Desert Storm, got out during the first Desert Storm and came here to Utah and started practice. My first office was near Trolley Square. And then after a few years practicing there, one of the attorneys that I was working with got tired of the law and started working for a construction company, and the other individual that I worked with was hit by a drunk driver and was disabled, so I was the last man standing and opened up an office on 7200. I've been doing Social Security disability since about 1996, and I do workers' comp disability and long-term, short-term disability plans that are offered through the employer or the state, or some people buy private disability plans. But if you have any questions about those particular issues, I can answer those questions. I did want to bring to your attention today a new policy that was passed by the Social Security in 2012, and you have a copy of that. And it kind of encapsulates what you already know about fibromyalgia and what the different objectives are for diagnosing fibromyalgia. I'm actually developing, I haven't quite got it done yet, but I have a form that it'll probably be completed within the next 15 days that doctors can use that follows this particular policy, that if you know anybody that is interested in getting disability based upon fibromyalgia, they can use the form, and it's very easy to follow, very easy to check off the different symptoms, the findings, the testing, and the other things that have been done to diagnose somebody with fibromyalgia and thereby qualify them for Social Security disability. I'm not sure how many of you have attended a lot of these educational meetings or the conferences that we've had in the past, and probably many of you are very educated about Social Security, but just let me give you a quick overview. The Social Security Administration has 2 different programs for people that have disabilities. There's supplemental security income and what we call DIB, or disability insurance benefits. Both of these programs for providing benefits to people with disabilities require that somebody be disabled prior to getting the benefits. And there's a 5-step process that the Social Security Administration will go through to determine if somebody is disabled. But generally speaking, if you are able to make about $1,000 a month doing whatever, in fact, I even read a case recently in a policy where somebody was engaged in illegal activities, and there's policies on people that are engaged in prostitution or pushing drugs or whatever. Those can actually count as valid work because it shows that those individuals have that ability to do that, maybe. But anyway, the general guideline is if you're able to make $1,000 a month or more, then you probably are not entitled to disability. I have a lot of clients come to me that get on disability, and they ask me, well, if I can do something, I want to go back and do some part-time work. Is it okay if I do that? And I have to give them the advice that, well, yes, you can make up to about $1,000 a month and be safe, but that doesn't necessarily guarantee you that Social Security will not look into your case and review it. Because again, what Social Security wants to see is, are you capable of making that amount or more? Not necessarily are you making that amount or more, but if I do have clients that are working part-time, I just tell them to go ahead, work. If you start to to get to the point where you think you are going to make more than that and you're going to go over the limit, come and talk to me, and we can talk and discuss whether or not that's particularly wise in your particular situation. The other reality is when people can make a living getting something other than Social Security, even though it may be a little bit more difficult, they're for lots of different reasons better off if they can do that. But the reality for a lot of people with chronic fatigue and fibromyalgia is that they have a certain limit, and if they go beyond that limit, they're just going to put themselves into a situation where they're worse off. But there's a lot of different considerations to look at when you decide whether or not you're going to work. But anyway, both of these programs, Supplemental Security Income and Social Security Disability Insurance benefits, require that you are disabled before you qualify for them. The way that the two programs are different is for regular Social Security disability benefits, you have to have worked during your lifetime, or you may be qualified based upon a parent or a spouse's work during their lifetime. But in some means, somebody has to have contributed to the Social Security system in order for you to qualify for those benefits. So if you've been somebody that's been involved in the work field and you've worked a significant period of your life, and there's different ways that Social Security decides that, then you would qualify for that type of disability benefits. The other type of disability benefits, SSI, you don't have to have worked, you don't have to qualify through another person, you have to be needy, however. You have to be somebody that is doesn't have a lot of assets, and there's an amount of $2,000, and then there's certain assets that do not qualify for that amount. I mean, you can have a car up to a certain amount, you can have one residence where you live. But again, it's a mean-tested program. If you're married to a spouse that works, or if you have other income that's coming in or other means in which to survive, then you don't qualify for SSI. And then under the SSI program, if you are making income, there's also a way that if you make a certain amount of income, if you get to a certain point, then you will no longer be qualified for any money from the SSI program. But you have these two programs, and they both require that you're disabled. One, you have to be needy, and the other one, you have to have worked in the workforce in the United States or qualify through another person, either a parent or a spouse. And if you need any of the details of that, we can get into some of the details, or if you have questions about it. The good news that you may have all heard if you've gone to these educational meetings is that, and it's okay if I turn this right. There we go. The good news is that as far as all of the forums in which you could be seeking assistance because of a disability based upon fibromyalgia and chronic fatigue, probably the Social Security Administration is the most advanced as far as understanding the two illnesses. It wasn't the case when I first started. We had lots of fights and a lot of education to give to the administrative law judges. And as a result of that process, and I believe as a result of some of the efforts of Dr. Bateman and the results of the efforts of OFFER, the Social Security first, several years ago, passed a policy on chronic fatigue, and now they have this new policy on fibromyalgia. And I think that's part of a result of our efforts and the efforts of many other people across the country to get that education to the administrative law judges. In order for this policy to work well for you or for anyone that you know or any of your loved ones, the most important thing that I can tell you is that you need to make sure that you're getting the medical care, you access medical care. If for whatever reason, because you don't have health insurance, you don't have money, or you don't have other means to access health care, you should be coming and seeing somebody like me. I have a pamphlet that I have in my office that talks about the different places in Utah and the different means by which you can get medical care. But again, the most important thing is you have good documentation of your particular illness, whether it's chronic fatigue or fibromyalgia, and that you're seeing your doctor consistently, And when you see your doctor, I have a few mistakes that a lot of people make when they're dealing with a doctor. Number one, you want, of course, to try to follow your doctor's advice. If your doctor gives you advice that for whatever reason is not working for you, if they prescribe a certain medication that is not working or has adverse effects, instead of just deciding on your own not to follow that advice, it's my advice as an attorney that you discuss with your doctor and give your doctor the information that your doctor needs to determine how effective the medication is that you're being given. You explain to them what the consequences are, the side effects, and why it isn't working for you. Or if it has to do with the expense of a medication, you also explain that. Therefore, that gets documented in your medical records. And when a Social Security judge looks at your records, a Social Security judge, one of the ways that a judge can turn down your benefits or your application for benefits, if they believe there is some medical care that would help make you better and you are not reasonably taking advantage of that medical care, then benefits can be denied in that instance. So make sure that, again, you are seeing a doctor on a regular basis, or your loved one is. You're following their medical advice, and if you cannot follow that advice, that you discuss that with your doctor and do it kind of in a non-challenging way. Many of you may have learned in coming to these educational meetings that sometimes we have to educate our doctors. And Dr. Bateman, this wouldn't include here, but some doctors are like many people that have a lot of knowledge. They don't like to think that you have anything to tell them or to educate them about. So if you do that in a way that is non-challenging and you let them think that they've come up with the ideas and that you're kind of guiding them, then they'll be more receptive to your guidance in their treatment of you. Anyway, as I said, you need to follow up with your doctors. I would restrict conversations with your doctors about your medical care. There's nothing wrong with going on vacations. There's nothing wrong with getting together with your loved ones and other things. You just have to be careful about how you approach that when you talk to your doctor about it. Certainly doctors like Dr. Bateman will want to know what your level of activity is. But if you just tell somebody, oh yeah, I went down to California to San Diego. Is it Disneyland is in San Diego, have I got that right? Or you even said, well, I went to Disneyland with my kids. Well, you going to Disneyland with your kids may be that you went there and you got one of their assisted, I don't know if you call them wheelchairs, but you were using a wheelchair or some sort of device that helped you be mobile where you didn't have to walk around. And you, in actuality, just went to a couple of places and just sat there and watched the kids and did whatever, and you didn't participate in a lot of activity. That's a very different activity than most people, or that's a very different way to spend your time there than most people would spend it. And those little details are very important because some of the judges here will use that kind of information against you and impute and assume all sorts of different things that you did when you were in California because of that little notation in your medical records. So again, you need to be cautious about the way you talk to your doctor. You need to tell them what your symptoms are. When you are engaged in activities, you need to explain exactly how active you really were when you went on vacation or did certain things. Anyway, after you've been to your doctor and you've gotten a good medical record, my recommendation to you is that you contact, and I would give this even to your attorney if you didn't hire me. We attorneys share information, we share forms. As I said, I have what we call functional capacity evaluation that I'm developing based upon this particular policy. But you'd want to get that and have your doctor fill that out to describe exactly, again, what the doctor has found in any testing, if anything, what the doctor has eliminated through testing, that the doctor has found the sufficient amount of time as far as having pain symptoms, and also that the doctor has found some of the widespread positive tender points that you have. And when the doctor can document all those things, then you're more likely to get disability benefits. The other thing that I recommend as far as an approach to disability is that when I first started doing this work for Social Security clients, I didn't want to take any of their money unless I felt like they really needed an attorney. And so when I first started, I would advise my potential clients to file their application for disability benefits and to work with the Social Security Administration up until the point they were asked to go to one of the Social Security evaluators, the doctors that Social Security hires to evaluate them, or they got to the point where they could ask for a hearing. My reasoning was that many people that apply, when they first apply on their own, they sometimes get their application approved without an attorney. And I thought, well, why hire an attorney if you have this process in which you can get approved and you won't have to pay an attorney anything? I charge, and most attorneys charge 25%. That's what we're limited by the Social Security regulations. We can charge up to 25% of back due benefits up to a cap of $6,000. Now that cap has moved up from time to time, and it will probably move up in a couple more years. But that's what we can charge. And again, I was trying to save potential clients money. But as I've been more and more involved and done more and more cases, and I've read people's applications, and I've read what administrative law judges or DDS, the office that processes the application, have said about some of the things that people put in their application or some of the things that they note in their disability report. Unfortunately, a lot of people make some very simple mistakes, and because of those simple mistakes, it makes it more difficult for them to get benefits. So my philosophy and strategy has changed. Now I like to be involved as early as possible in the case to make sure that nobody is making any of those very simple mistakes. And again, with the 25% of any back due benefits, with that being the limit of what I can charge, oftentimes when I have people come to my office, they hire me, we do their application, we fill out the disability report. If they are approved early on in the process, sometimes there's no fee. And I just had 2 cases in the past year in which there was no fee. And the reason there was no fee is you get, when you apply for regular disability insurance benefits, they don't pay benefits for the first 5 months. You have to be able to show that you are disabled for a year, or you're going to be disabled for a year, or you're going to die within a year in order to qualify. But if you're applying early on and you're approved at a point where there's no back due benefits, then there is no attorney fee. And so I've had that situation arise. I've also had, at the beginning of last year, I had an attorney fee of $11. And I've had another attorney fee of $200 a year and a half ago. But did you have a question on that?
They don't pay for the first 5 months upon approval, or
Good question. They don't pay for the first 5 months of disability. For regular disability insurance benefits, you indicate the day that you became unable to work. And on the day that you became unable to work, or on the day that Social Security finds that you were unable to work, they don't pay the first 5 months. And that's different than SSI. SSI pays on the month that you apply. And sometimes when somebody has worked for a very short period in the workforce, because regular disability benefits are higher depending on how much you paid into the system, and sometimes they can be very low so that somebody will have a right to receive both SSI and regular disability insurance benefits. And if I have a client that is in potentially those two camps, I will go ahead and have them apply online, and I help them for regular disability insurance benefits. But you cannot file an SSI application online yet. You have to still call up Social Security Administration and start and have an appointment with them. So we do the one first, and then we call them up to file their SSI application. Anyway, as indicated, I like to be involved at the very beginning to make sure that the application is filled out. One thing that you should know, if again you're dealing with a application for Social Security disability benefits, or you're talking to anyone that is or they're going to, during the Bush administration, and I know a lot of people hate to hear us talk about things that started during the Bush administration, but during the Bush administration, because of a lot of budget constraints, there was a lot of money that was taken out of the administration, not necessarily out of benefits, but they defunded parts of the Social Security Administration itself, and so the Social Security Administration was losing 4 people to every person that they were hiring. And so the administration kind of shrunk, and the work level didn't go down. The work level actually increased because we have a lot of people. We have an aging population with the baby boomers, so there were more people that were eligible. And so, as you may have heard, there was a backlog that was created. During the last 4 years of the Obama administration, they have somewhat decreased that backlog, but there is still a significant backlog. So not only do I don't want clients to make mistakes, I don't want clients to do anything that would slow up their application, because you want to make sure that you're keeping everything moving correctly. And with the backlog, that is even more important. But the reality is that until you get up to the point where you're asking for a hearing, there is not a lot of lawyering to do. And sometimes I have clients, and I've heard this with other attorneys, we talk about our caseloads, and we talk about our clients. Somebody will come in and hire me. I will help them with their application. We get approved before we have to go to a hearing. You know, I have usually a very small fee, maybe a $1,000 fee, and they'll come ask me, well, Lauren, you didn't do anything for me. Well, sometimes all I do, and the best analogy that I can think of, and we've all heard this growing up, especially in this community, if you are headed to the moon and you have your spaceship headed in that direction and you just deviate a very slight amount from that direction, you're going to be, hundreds of miles not hitting the moon. Well, sometimes a Social Security application is like that. If you just make one small mistake, that can make the difference between winning and losing. And sometimes all I do as an attorney is I am like a travel guide. I'm just making sure you don't get lost. I'm making sure that the robbers don't get you, that you stay away from the robbers. There are cases, well, I can tell you this, sometimes I'm somebody's attorney and we have a successful application, and I look back on everything and I think, hey, they may have been able to apply on their own and done well without me. Other times, and I just had this situation in December, I had somebody hire me 10 days before the hearing in November. They hired me right after Thanksgiving, and they had a hearing the 1st of December. And I got his application and I got all his records and I read them. And there were some things that he was doing that I knew were going to, he wouldn't have been successful without an attorney. And actually, those kind of cases make me feel really good because I really feel like I made a difference. But I know we won because I knew the judge that we were presenting our case to, and I knew some of the things that he had to do to make sure that he showed his disability, which he did have, and he did have. I thought it was a meritorious claim, but I don't think he would have won without an attorney. And I've had many cases in my career that I think that has happened. But anyway, that's what I want people to have an attorney on the get-go to help with their application, help with their adult disability report. And then at that point, we work it through the system. If they're denied the first time, then we have to ask for reconsideration. If they're denied their reconsideration, then we have to ask for a hearing. And when we are going to the hearing, the most important thing, if you file on your own, besides getting proper medical care and going to a doctor, is then you need to make sure that every scrap of medical evidence that you have is presented to the administrative law judge. A lot of people think, oh, I just have to mention this doctor and get this record, and then it's clear I'm disabled, I'll win. My approach, and most attorneys' approach, and we're usually limited by time and budget, but what I try to do in every case that I have is I certainly know with certain judges and with certain cases what the probabilities of success are, but I still try to leave no stone unturned, to turn over every leaf and present every bit of evidence that I have that will help myself and my client present our case in the best way possible to be most persuasive. So that's what we do before going to a hearing, is just making sure that we have all the evidence that we need. If there are problems with that evidence, if there's information that I need to still get, then we go out and get it. If there's information that I need my client to address at the hearing, or if I need witnesses to come to the hearing, then I have them and we present that evidence at the hearing. And then if all is successful, it usually takes about 2 months for the decision to come in after the hearing. And let me back up. When I talked about a backlog, it still can take 2 years to 2.5 years from start to the end to finalize a Social Security application. And then if you have to appeal, it could take a lot longer than that. But anyway, it takes 2 months, about 2 months to get a decision, and then around that time the monthly benefits start coming in, and anywhere from 2 months to 4 to 6 months to get your back due benefits. Anyway, that's kind of a very quick overview of Social Security. And as I said, if you look at this policy and read it, it'll tell you the kind of things that you need in order to establish a case based on fibromyalgia. This particular policy is very similar to the chronic fatigue policy as far as the way it's set up and worded. Social Security still likes to try to establish objectively that you have an illness, and then once they've established that objectively, then all the subjective symptoms and other problems are considered. There still are a couple of judges here at the Salt Lake ODAR that are difficult when it comes to these illnesses. There's ways that I've learned to try to, and sometimes I'm very successful, get around their difficulties that they have with this and make sure that people get approved, if not by them, through an appeal. And the appeal process is first to the Appeals Council, and then if that is unsuccessful, you appeal to the district court here in town. But anyway, having kind of gone over a very quick overview of that, what are some of your questions? And you don't have to restrict your questions to Social Security. You can ask me questions about long-term, short-term, or workers' compensation, or the state's program through PEHP, which is probably the most difficult form in order to try to get a approval of any kind of disability because of fibromyalgia and chronic fatigue. And also, just to let you know, the reason that I've ended up having a lot of clients that have chronic fatigue and fibromyalgia, and the reason that I got involved with OFFER is that in 1983, I was a river guide on the Snake River, and there were a few other little things that started happening with my health, but I had some changes in my health, some things that were a little off, and I was kind of wondering what was going on. But I worked on the river that summer, climbed Buck Mountain and sprained an ankle really bad, and then when I drove home the following day, I had to pack up and hop on a plane for a year study abroad in Spain. And while I was in Spain, this ankle that I had that was hurting me, it never got better, and then I had kind of pain symptoms go from up one leg into the other, back and everything else. And by the time my year was up in Spain, I came home and couldn't sleep, had all the pain that everybody has with fibromyalgia, and spent several months, almost up to a year, going to doctors until I got to a doctor who could diagnose fibromyalgia. And after that diagnosis was made, and I was given ibuprofen was what they started me with, and amitriptyline to help my sleep. But once I got my sleep regulated and I got on an anti-inflammatory, it's been kind of a nuisance in my life to have fibromyalgia, but it hasn't been disabling or debilitating. But it's something that I've learned and had to deal with since that period of time in my life. So I, of course, become very knowledgeable. And the interesting thing about having a chronic illness is that, of course, you learn a lot about doctors and about the medical system and what they do or do not know, and how arrogant they can be, and how presumptuous they can be, and all the other things that you run into. And it also taught me, of course, a lot about people and living and other things. So in a way, I kind of look at it as a blessing in my life. Unfortunately, it's not that way for a lot of people. A lot of people are, of course, debilitated and have a lot more problems than I've had. But I've had to deal with that socially and financially and in all the other ways that we have to deal with it. Anyway, any questions that any of you have? Go ahead.
On the function report you have to fill out as part of the Social Security disability application, it lists, I want you to put basically references down, like employer, family member, reimbursement. But on the form it says you may choose not to complete this form. Do you have a recommendation or a guideline for that?
When you say not to complete this form, what specific form are you referring to?
Report, and it's that first page on the...
Oh, okay. This is what I would tell you. I would always err in favor of giving information than not, but of course, the only time that I've had where that came to haunt a client is that I had a client that gave references to people that didn't like the client. Or I've had loved ones who, when I talked to them in my office, they were very supportive. And in a few cases where you have people that don't believe in it or think that their loved one is, of course, trying to perpetrate a fraud, then I get them in the hearing and they don't have very good information. I do everything I can to make sure that is not the case. But typically I'm giving all of the information possible. Now, probably a good question that has to do with this is how much credence or what weight or what value does Social Security give other people's information? Very little. Except, and when I say other people's, I mean just non-medical personnel. Except that there's this tension with administrative law judges that you need to understand. And this is true of every human being. You always have to evaluate what is it that the person that I'm dealing with wants, or what are their interests? What are they trying to accomplish? And you have to understand that an administrative law judge doesn't get paid any more or any less whether he has 1 billion cases that he spends 100 hours on each, or whether he has 10 cases and he spends a half hour for a hearing on each. Administrative law judges, of course, they want to do a good job. But they're human. And when I approach a case, is that I get ready for it and I have my clients assemble a small handful of people that I interview, find out what they know, look at all the information I have and decide, in this case, would it be helpful to have a lay person come and provide testimony? And then I try to limit the amount of people that I have come and testify so that I'm only imposing upon the judge to the degree that's absolutely necessary to get my point across. And judges are very resistant. A lot of Social Security attorneys don't ever have any witnesses. They just have the claimant there. I know of dozens of cases I would have lost if I had no witnesses, because sometimes they have very critical information that is very helpful. But it has a lot to do with more of being an art than a science, and looking at who's the judge I'm dealing with, what are the symptoms and the objective evidence, and how can a lay person help. And frankly, in a lot of chronic fatigue and fibromyalgia cases, it is good to have witnesses. If you have a few really good, strong witnesses that have known the person that's applying for a long period of time, kind of knows their background and how they've been in their life, and then what they're like with their illness. It was like with me, people that knew me when I was growing up, very athletic, I'm very driven, I'm still very active now, but if you saw how active I was before I had fibromyalgia compared to how I was after, I mean, there was a night and day difference, but nobody would know that unless you knew me. But when I would go to these doctors who never knew me, that would just assume certain things about me, that's what you don't want to have happen. You don't want an administrative law judge assuming stuff about you because of this one little tiny slice where they get to see you for an hour or 2 hours. And so for that reason, I think lay witnesses can be very, very helpful. But again, it just depends on each case. But I would give them as much information as you can as a general rule. So there was a bunch of other questions.
Is there an age limit?
For Social Security, at age 65, you go on to normal old age pension. So that's the age limit. And sometimes people will be nearing age 62 where you can go on Social Security earlier, and they're wondering if they should still file for disability. You should still do both, because if you win your disability application, even if you went on early retirement to survive, they will go back and recalculate it, and you won't be penalized for having gone on old age pension early. Does that answer your question? And you can get, there's a lot of people don't know, you can get disability benefits if you are a child also. So, other questions? Yeah? No? Go ahead.
If you were to apply for this and actually get it, are you covered medically under Social Security or Medicaid or Medicare or any of that?
For Medicare, you have to be disabled for 2 years. So the sooner that you can apply and the earlier you can establish your disability date, that's when they calculate those 2 years. Now there's been some movements in Congress to try to change that. I don't see that happening anytime soon because it was almost, I don't know what you call it, a miracle or act of God, or however you view it, whether you view it or bad. I mean, it was hard. President Obama spent all his political capital to get the changes that he wanted to make, whether you agree with those or not. And I doubt that he could spend any more political capital trying to change the 2-year limit on Medicare. Medicaid, you get Medicaid based upon need. If somebody needs medical care, you need to go to the state and you apply for the medical care and you apply for Medicaid. So Medicaid is a a needs-based program. Medicare is for old age or when you're disabled and on regular disability insurance benefits. So
My company has short-term disability and long-term disability insurance. Would Social Security look at that and say she's got this? I'm 62. Would they just kind of install?
they are not supposed to. And when I say they're not supposed to, most of the judges, I think, follow that. There's one judge here that I've worked with that I know he takes that into consideration. He tried to, and now that I've had experience with him, I would have done this. But I have an ethical obligation not to manipulate things so that they're at the detriment of the short-term and long-term disability provider. Because you may know this or you may not. All of the short-term, long-term disability plans that I have looked at offset Social Security or any other benefits like workers' comp against their benefit. So, for instance, if they are paying, I'm just going to use a number so you can understand this. If they agree to pay you $2,000 a month if you become disabled, if you get $1,000 in Social Security, they'll offset the $2,000 they're supposed to pay, and they will only pay $1,000 a month. That's how all of this long-term, short-term plans I've looked at are set up. There may be some that are private plans that aren't set up that way, but they're very expensive and they're not offered as employment benefit plans. But going to your question, does Social Security take that into consideration? No, Social Security Administration is not supposed to take into consideration those types of plans. They will take into consideration your workers' compensation. If you're getting workers' compensation, then they will only give you a total amount of 80% of your average cumulative. I want to say income, but it's not income. But they take the last 5 years or the highest earning years, 5 years in a row. They average the income during that period of time, and then they figure out a monthly income, and they will only let you combine workers' comp and Social Security to get 80% of that income, which means that they will diminish your Social Security somewhat. I've never seen an instance where you're not better off trying to get both, and in fact, I don't know that I can theoretically think of an instant where it would be detrimental. So you always want to try to get workers' comp if you can, but that's what they look at. And there's also a reduction when you get veterans benefits, and I'm not sure exactly how that works. I haven't had to contend with that. But long-term, short-term, there's no effect. Is it taken into consideration? A couple of the judges will, because if they're not really compelled to believe that you're disabled, they can justify what they're doing. They can rationalize it and say, "Oh, she's being taken care of by the short-term, long-term disability, so I don't have to give her this." I was getting back to your question. One of the judges tried to do a deal with me. Well, she's getting short-term, long-term disability. Why don't we do this? And in my opinion, I had an obligation, and the client had an obligation not to do anything that would detriment their rights. And I thought that would have been unethical to have done that. I still think it's unethical for the judge to have proposed it in an indirect way, not to the point where I could really do anything about it. But today, I probably would have tried to have dealt with the judge, but done it in a way that protected the rights of the insurance company and still got my client some Social Security benefits. But anyway. Any other question on that? Well, one thing that you have to, if you know anybody out there that is applying for short-term or long-term and trying to get it based on fibromyalgia, chronic fatigue, or something else, the thing that you have to know about those programs is they're governed by ERISA, and ERISA is a federal law that has taken away a lot of your rights. if you're denied short-term, long-term disability benefits, you will never go before a judge and present your side of the case and present your doctors and present your evidence or your testimony in live court. All you do is compare what you presented to the insurance company, and then the judge is supposed to determine if there is some plausible or reasonable explanation to uphold what the insurance company did. And that's a very hard thing to fight an insurance company based on that, because insurance companies know what they need to do to give them a reasonable argument about why they turned down your benefits. And out of all the areas, I think that it's critical to have an attorney on that unless you have a really clear-cut disability, or whether for short-term or long-term. Unless you get it at the first, when you first apply, you get it right off the bat. You probably don't need an attorney, but anything beyond that, you should have an attorney.
You mentioned workers' comp. How does that play in with CMS?
Not very much, because with fibromyalgia, it is actually in the statute that that will not be covered by workers' comp. Whether that's true of chronic fatigue or whether that would remain true if the science is advanced to the point where we can prove objectively what caused the fibromyalgia or the chronic fatigue. But the thing about that is you can get approved workers' comp for residual, like RSD, residual or regional. I keep forgetting that name for it. Regional symptomatic dystrophy or something. Whenever you get a pain complex, there's various names for different pain complexes that can occur that are not widespread, like with fibromyalgia. Some of those things you can get workers' comp benefits for them, as long as you can link the workplace accident as having caused the RSD. So, other questions?
I have one question. I am 71, and I've been on Social Security since 62. But since I've had fibromyalgia, which has been diagnosed the last 2 years, my expenses have really gone high because of the medical part. Would they readjust my Social Security if I could?
No, I don't know of any way that I could help you there. Did you, when you started on at age 62, when you started drawing Social Security, did you do that because you were disabled and unable to work? Okay. Yeah, a lot of those problems with the increase in medical expenses and other situations, those are political problems that need to be addressed. But I don't know of any legal advantages you have now of adjusting anything. So, anything else? Again, you can ask me anything. If you want to ask me a question about why attorneys do this or why attorneys do that, or how do we get rid of attorneys that do this, or whatever, I'll answer those too. Or,
If they're, does Social Security come back and reevaluate? So say you're granted a Social Security, would they ever come back and reevaluate you and say, yes, you still qualify, or no, you don't qualify? Or?
yes, they do. And they'll do so, and I don't know. For instance, if somebody's worried about getting edited or audited by the IRS, there's probably people that know exactly the little details they look at. I don't know that, but you can get reevaluated if anybody makes a report saying, hey, Joe Blow, my neighbor, is on Social Security disability, and I saw him out pulling his deer down the mountain and then doing somersaults. I think he should be reevaluated. They'll investigate that. I've had specific cases that I'm involved with where the judge specifically says, I want Social Security to reevaluate your case in a year or in 2 years, and they'll do it under those circumstances. Or if any information comes to their attention where they think that your particular case needs to be evaluated, maybe there's been an advance in the science in a particular illness, and they think that that may be having a positive effect upon the people that are having those illnesses, so they'll look at a few of those cases. And I have helped one client with chronic fatigue that was actually 2 that have been reevaluated. And in the one case, the judge asked that it happen every so often. And what those two clients had to do is, again, gather all their medical evidence together. And that's why it's important to, as consistently as possible, be going to a physician periodically so they have information, they can show where they are, and they just had to present that evidence to Social Security, and the benefits continued. So, any other?
You said you work a lot with employer disability insurances. Okay, forgot my question.
It'll come to you in a minute. Somebody, go ahead.
I was warned by someone who had my employer's plan, who was on disability, and she said, they will kick you off real easy. I mean, does that happen a lot? Is that something to be worried about?
Yes, it is something to be worried about, but you only can worry about what you can have an effect over. And again, you do the same thing that you do for Social Security. You make sure that you're being seen regularly by a doctor, you're giving good information to them, you're making sure that you're qualifying information that could be looked in at the abstract to mean that you're now better. And you need to make sure you're complying with your doctor's recommendations, and if there are recommendations that you cannot comply with, you explain why, so that can be adjusted. But I think it was Unum, UNUM, or one of the other plans that bought out another plan, and when that happened, they did a wholesale review of specific cases with people with specific diagnosis, and they kicked a whole bunch of people off. And they know, there's cases where certainly that's justified, but there's other cases where, as I like to explain, if you line up all my clients that I've been able to help get long-term or short-term disability, and you compared the ones that got the short-term and long-term disability to the ones that didn't, you would think, well, this would be the sicker group. The group that got the benefits would be the sicker group. No, it doesn't have anything to do with that. There's no rhyme or reason. It's usually, did the people that get them have a diagnosis that is more acceptable, or did the insurance company goof up in the way that they processed the claim for somebody, and therefore they lost that claim? And usually, in a lot of the situations, we're taking advantage of mistakes that the insurance company made as opposed to proving that the person is disabled. There's a lot of people that don't get short-term and long-term disability that are disabled, but the system is set up to where it's not really fair. You don't really have a fair chance of proving that. So,
do you coach your clients before they see a doctor or a psychiatrist?
if they're going to an evaluation by Social Security, or for instance in workers' comp, if the workers' comp insurance adjuster wants them to see one of their doctors, yes, I'll sit down and talk to them. But there's really not, other than making sure they just listen to the questions, they answer it, they don't treat the doctor as their best friend or as their enemy, they're just professional. I mean, that is generally the advice that I give them. I mean, I usually know what the outcome of most of those evaluations are going to be, but sometimes I attend the Social Security evaluations and the workers' comp evaluations, depending on the particular case, and I do that quite often. It's very educational, and sometimes it impresses. Not very many attorneys do that, but I think at times it impresses upon the doctor the fact that, you know, we care about this case. I care about my client. I want you to do a good job. Whether that makes a difference, I don't know. But the problem with the whole system of doctors evaluating people to determine how sick they are is that, like all things where there's a lot of money involved, and it's not that necessarily all doctors that do this have decided, well, I'm going to be corrupt. It's just that the ones that have a certain very militaristic ideology, they tend to, they don't do this like they make a plan, it's just their personality, their view of the world, that everybody can pull themselves up by the bootstraps. And that, works sometimes. But when they have that kind of mindset and they start doing these evaluations, the insurance companies see, oh, this is the doctor that almost always says stuff that we want him to say. And therefore they continually hire the same experts time and time again, and all the insurance companies get to know those experts, and those are the ones that are used. And they make a ton of money. Millions, many doctors that do these evaluations make $2 to $3 to $4 million a year just doing evaluations. So, and the insurance companies know which ones to use. If they figured a way to take the money out of it, and there's always got to be some money because everybody has to make a living, but if they made it more random, I thought of different ideas and took the money out of it, I think we'd get more honest opinions. But anything else?
Why does Social Security send out the same form to be filled out more than once and multiple times?
Smarter minds have not prevailed, but what I tell my clients, because each step of the way they do that, I just say, if nothing has changed, just put in there, nothing has changed, same as last, or, I have no new information.
So they're looking to see if there's any change.
Yeah, any new information that might persuade them. Some of us, I've done this a few times, I know some of the other law firms do it. If we have a really compelling case, and the evidence is there, we will sometimes submit kind of an argument with that evidence to the DDS or even to the law judge to try to get a favorable decision prior to the hearing. But there's some cases we just know we are going to go to a hearing. Most fibromyalgia cases, chronic fatigue cases, are going to go to a hearing. A judge is going to want to talk to you. A lot of low back cases where, they have some findings on their back that are abnormal, some derangement in their back. But low back problems, you can get the same x-ray on 10 different people. 5 of them will be fine, and 5 of them will have a lot of pain and be disabled as far as looking what you see on the x-rays or the MRI or whatever. So a lot of low back cases are just going to go to hearing. I know when I review the facts of my case, basically if we're going to have to go to a hearing. Sometimes I'm wrong, usually not. Sometimes I get approved when I don't think I'm going to get approved, and sometimes the other way. But generally we can kind of figure out what's going to happen. That's why they just are trying to be thorough, and on the other hand, sometimes they are a little bit, you're dealing with a very large organization where they don't have a lot of time to think individually for each case. So we just make sure they do the same thing with each case. So, anything else?
Can I ask something a little off topic?
Yeah.
What was the deal with your sleep and the drug? I'm new into this and my sleep is really messed up.
Well, of course, I'm not a doctor, so I'll qualify with that. But for me, what happened is I started having all these pain symptoms. Along with the pain symptoms, I started just not being able to sleep. And I would, and a lot of doctors ask you, well, is it trouble going to sleep or staying asleep? And at the beginning, it was trouble. I could go to sleep for a few minutes, and then I'd wake up, and it was like, as far as my mind was concerned, not as far as the rest, it felt like I had slept for, 8 hours, and I just couldn't get back to sleep. And I got to be a very good chess player during that period of time because I had one of those computer chess boards, and when I couldn't sleep, that's what I would do, is I'd play chess. And then during the day, I'd kind of nap when it would hit me, and I'd be able to sleep. But for a year until I got diagnosed, I had horrible sleep. But my 2 predominant symptoms were the pain and the inability to sleep. And of course, that's one of the things that are associated with fibromyalgia, chronic fatigue, and a few other problems. And some doctors think that the not being able to sleep causes a great array of some of your symptoms. So once they get your sleep under control, if they can, And not everything works for every patient. I know that from hearing the doctors. But once your sleep is regulated, then a lot of the other problems start taking care of themselves. For me, it was amitriptyline for years, just a small dosage, and then we changed a few other things because the amitriptyline kind of makes me drowsy. And as I start to age, that's kind of making the symptoms a little worse. Hopefully they won't really get really bad, but I've had to make little adjustments here and there. But when you can, just having a very a life that you're following a regimen that helps get your body ready for it, and that you have regular exercise when you can. And I realize not everybody with fibromyalgia or chronic fatigue can do that, or they have to redefine what exercise is to them. But along with being consistent in my exercise, not pushing myself beyond certain limits, and I have to relearn those as time goes on, and just taking the anti-inflammatories and the sleep aid, and I've been led a pretty normal lifestyle. Nobody would know unless I told them. And I learned that when I was dating, not to tell anyone until, it was too late. They were already in love, so the trap was set.
Do you ever deal with the Department of Labor?
In what respect?
Under the OWCP,
OWCP.
as a federal employee?
Oh, I have not. There are attorneys that do federal workers' comp and then other federal problems, but I haven't. I've represented people in merit system board, protection boards and other things, but I haven't had a lot of dealings with that. So.
How are you compensated? You mentioned that you can be compensated up to $6,000 if you win the case. Does the person have to then pay that out of pocket, or?
It comes out of the back due benefits. From the time I represent them, of course, they don't have their benefits, and as much time goes by from the time period that they were disabled, beyond those 5 months, they start accruing monthly amounts that Social Security owes them. And so at the point they're approved, Social Security calculates what their back due benefits are. 25% is taken out of that automatically by Social Security, paid to me up to a cap of $6,000. Now, if I appeal to the district court or to the 10th Circuit Court, I can get paid more than that under another program, federal program. But anyway, it's generally 25% up to a cap of $6,000.
So is that on top of a retainer fee, or?
No retainer, no hourly rate. We can charge costs if we work that out with the client. Like if I have somebody evaluated, typically what I do if I go ahead and decide we're going to get our own evaluation, I either advance the cost and they reimburse me, or they pay half and I pay half, something like that. Sometimes if I have, like, I'm representing a kid that has a pretty wealthy family, they're paying for the evaluation. So.
Is there a basic evaluation form that I can take to my doctor? She's taken care of me for years, but we haven't done the eliminate this, eliminate that,
When you say evaluation form, you mean to use in conjunction with a application?
Yeah.
I have one that I would give you. You would just have to call me and say you saw me, and then I would give it to you. Lauren Lambert. If you Google me, you can find me pretty easily. Very easy. I would caution you, though. You know how they say the internet, people find something. I had a guy I represented out of the prison, and he has badmouthed me on the internet because I told him that his case was only worth a certain amount of money that we were offering, and we could have had a judgment, and I could have got paid, and he just didn't like that. He thought I was selling him out when I told him that his case wasn't worth $1 million. So, not all cases are.
So you didn't bring any cards?
I kind of rushed here. I have some in my car. I could grab some. So if you give me a second, I'll run out there and run back in before you can make it out the door. So, but again, Lauren Lambert, I could give you my number. Loren, yeah. So, anything else? Again, any kind of question you have, I'll try to answer it, or try to get you to somebody that can.
Sorry, I have one last question. Again, this is to do with my application process. I had a horrible doctor that Social Security sent me to. Is there anything, should I report it, not? I mean, he just didn't know anything about illnesses. He thought he was doing a fingerprint exam. He took his fingers and just went like this and grabbed me all over and asked me if it hurt. That kind of thing.
You, in your case, and you should explain your background, it may be helpful to send in a little comment to DDS about that doctor and what happened, because you have some knowledge that led you have knowledge that made you aware that what he was doing was definitely wrong. 99% of the people that go to these doctors are not going to know that. And you may have some effect to where other people would not. Anything else?
Thank you very much.
Oh, thank you. And I, again, apologize for the misunderstanding that I had. So, if there's anything I can do to make it up, just call me and I'll see what I can do.
There's that